Hello, friends. Welcome back to our weekly update, where we dive into the latest and most exciting developments under the Income Tax Act, GST law, and corporate laws for the week ending April 6, 2025. We've got a lot to unpack today, so let's jump right in with some fascinating judicial pronouncements and updates that are sure to keep you informed and engaged. Starting with the Income Tax Act, there's been some really interesting action in the courts, and I'm here to break it all down for you in a way that's easy to grasp and, dare I say, a little fun. First up, we have the case of Mohammad Farhan Mohammad Yunus at Tarwala versus the income tax officer, decided by the Mumbai Tribunal. Picture this: someone buys a flat from a builder, holds on to it for a few years, and then sells it, hoping to claim a long-term capital gain. Sounds straightforward, right? Well, not quite. The assessee in this case argued that the holding period for the flat should start from the date of the allotment letter, not the possession date as per the agreement. The assessing officer, however, disagreed and treated the gain as short-term by pegging it to the possession date. But here's where it gets juicy: the tribunal stepped in and ruled in favor of the assessee. They said that since the assessee had entered into an agreement of allotment, which gave him title and interest in the property, the clock for the holding period starts ticking from that agreement date. So, 3 years down the line, the sale qualified as a long-term capital gain after all. A big win for the assessee and a reminder that the fine print in agreements can make all the difference. Next, let's head over to the Madras High Court for the case of MDA-HSG versus the income tax officer. This one's about who gets to call the shots when it comes to staying a tax demand. Imagine you filed an appeal against a tax demand, and you're hoping for a breather while the appeal is pending. You file a stay application, but the Principal Commissioner of Income Tax, PCIT, jumps in to decide it right away. The Madras High Court wasn't having it. They ruled that after filing a statutory appeal, the first stop for a stay petition under Section 226 is the assessing officer, not the PCIT. The Principal Commissioner can only step in later to review the order if the assessee isn't happy and files a reference. Until then, the assessing officer's order stands, and in this case, the court sent the matter back to the assessing officer for a fresh look. It's a classic case of following the right process, and the court made sure everyone stayed in their lane. Now, let's talk about a case that's a bit of a relief for taxpayers: Timothy John Brinkman versus the Director of Income Tax Investigation, decided by the Mumbai Tribunal. Here's the story. A British citizen, tax resident in India for just 1 year, forgot to disclose a foreign asset in his original return. Oops. But he quickly filed a revised return within the allowed time limit and included the asset. The revenue authorities slapped a penalty under Section 43 for non-disclosure, but the tribunal said, hold on a minute. They ruled that since the revised return was filed on time and there were no discrepancies, or any proof that the asset came from undisclosed, black money, from India, the penalty had to go. It's a sigh of relief for anyone who's ever made an honest mistake and fixed it promptly. And finally, under income tax, the Punjab and Haryana High Court delivered a lesson in fairness in Feendog Funvest Private Limited versus Deputy Commissioner of Income Tax. Imagine this: the assessee updated the assessing officer with new email IDs, but notices kept going to an old email of a chartered accountant who no longer worked with them. The result? The assessee missed out on defending itself, and an order was passed. The court didn't mince words, it quashed the order, saying the assessing officer violated natural justice by not giving the assessee a fair shot. It's a reminder that communication matters, and the taxman needs to keep up with the right contact details. Now, let's switch gears to GST law, where the courts have been busy setting things right. The Karnataka High Court stepped in when both CGST and SGST authorities launched parallel proceedings against an assessee for the same issue and period under Section 73. The court called it impermissible and quashed the orders, because who needs double trouble from two authorities over the same thing? Over in Gujarat, the High Court dealt with a refund tussle. The assessee got a refund approved but filed a second application because some invoices were missed the first time around. The department rejected it, but the court said that keeping the excess tax would be unjust enrichment on their part. They directed the department to process the second refund application, ensuring the assessee wasn't shortchanged. It's a great example of the court stepping in to balance the scales. Lastly, under corporate law, we've got two updates to wrap things up. The Insolvency and Bankruptcy Board of India, IBBI, has rolled out the IBBI, Insolvency Professionals, Amendment, Regulations, 2025. Here's the good news: if you are aiming to become an insolvency professional, you now have 24 months, up from 12, to pass the limited insolvency examination before applying for registration. More time to prep and ace that exam. And over at NCLT Hyderabad, they took a firm stand in a case where the mandatory steps for increasing authorized share capital, altering the memorandum and articles of association, allotting shares, and appointing directors weren't followed. The resolutions passed, declared illegal, null, and void. It's a wake-up call to stick to the rulebook. And that's a wrap for this week's update.